Hi, this is Professor McLaughlin. I wanted to record a, not too long, I won't say it's brief, but it's probably a 15-20 minute lecture on Chapter 18 on administrative law. I don't want to spend too much time on it because we've talked a lot about administrative agencies, administrative law. It's so important for businesses. So many administrative agencies regulate many industries. So let's kind of get into it. Administrative law, what this chapter focuses on are more the specific functions. In class, we've talked a lot about the cases, what the Environmental Protection Agency can and cannot do, but what this chapter does is really give you an opportunity to take a look in more detail at how they make rules, what they're required to do with those rules in terms of letting the public know that a rule change is coming, allowing a comment period, allowing a time for the public to say that's a bad rule. And what I'd like you to do in your mind is contrast this to how the state and federal legislatures make rules. Certainly, the public does not get an opportunity to comment and say this is a bad rule in a formal way when a law is passed, when Affordable Care is passed, when Congress changes the immigration rules. We allow the government to do that. We vote on representatives, and that's how we comment. But for administrative agencies, as I've mentioned before, because there's limited due process, because you do not have a right, the same rights of notice and a hearing to appeal decisions and to question any kind of sanction or action that's been taken against you. Built into the system are these opportunities for the public to be involved in the rulemaking process. And that's in more detail what this chapter goes into. So administrative law are rules that administrative agencies create or promulgate, but also administrative law includes the Administrative Procedure Act, which empowers the agency, limits the agency in its rulemaking ability. So it defines for the agency how they can make rules and what rulemaking will look like. So administrative agencies create rules, they implement them, meaning they pass them, and then they enforce them. So they go and inspect, they make sure people are complying, and all of this is done with an eye toward what the purpose of the agency is. So in this slide, it's the Department of the Treasury, and we're levying taxes, we're collecting taxes, we're giving that money to the federal government, we're chasing people down who don't pay their taxes, we're changing rules in order to encourage certain activities, encourage people returning to work and helping take care of children, giving tax breaks to nonprofits. And all of those things are driven by policy. And policy has to do with what do we see as the good or benefit that we're giving to society now as an agency? How are we using our power for society? And sometimes it's not necessarily just for the good and benefit of the people. Maybe we are giving government more power. We're responding to, for the IRS, we're responding to financial changes, changes in demographic in society. We're having a large population whose income is dropping, so tax revenues are falling. So this will provoke the administrative agency to make a policy change. And I just find that students sometimes struggle with this policy making function of laws and rules. All public laws are driven by policy. Immigration rules are driven by immigration issues, immigration policy, a growing group of immigrants, a diminishing group of immigrants, problems at the border. That drives policy. So all policy is in policy making is defining what we're doing here. And I guess in a kind of analogy, it really is like a family. If you have a family, a couple with children, their policy as a family is going to be driven by raising children, vacationing, saving money for everybody's needs. There's 4 of us. That changes once the children grow up and leave home, and the policies change. I downsize my house. I help my children in different ways. I babysit. I maybe provide a down payment for a mortgage, or I live with them. So it's slightly analogous. It's not a great example. So take a look in the book on the discussion about policy making. So that's a big part of administrative agency function. Oh, I should have put that slide up. Then you could have looked at it. All right, well, go back and look at that. So policy making. But another thing administrative agencies do is they inspect and investigate. They want to make sure people are compliant with health and safety rules, the Food and Drug Administration. If you're warehousing food, are you keeping it safe? Packaging, inspecting elevators, all of that kind of stuff. And then recommending a fine or a sanction. Those are also a large part of what administrative agencies do. They also, in certain industries, can provide a license and testing requirements. Certainly in the securities industry, to become a broker, you have to take a test. To manage a brokerage office, you have to take a test. To sell insurance, you have to take a test. And this is all about licensing and permitting. Permitting is really more, if I have toxic chemicals in my manufacturing process, the EPA may require me to dispose of them in a certain way, and I may get a permit to store them on site. I may get a permit to emit pollution to a certain degree, and the Environmental Protection Agency over time may limit me. And so I need to get filters. I need to control my manufacturing process so that less pollution is emitted in compliance with the permit I've received in order that allows me to pollute, essentially. This kind of goes without saying. I mean, this example, the Social Security Administration distributing retiree and medical benefits to eligible citizens. Certainly one thing that some administrative agencies do. So where do you find administrative law? It's in primarily, I would have reorganized these bullet points, primarily in enabling statutes and common law. So the enabling statutes are the statutes that created the agency to begin with. In 1971, Congress passed the Environmental Protection Act, which created the Environmental Protection Agency, and then the Environmental Protection Agency. I'm sorry we keep talking about the EPA. It's a really good one. And I know all the dates. The EPA passes laws. Those become administrative laws. And when they pass those rules and laws, they have to comply with the Administrative Procedures Act. Congress, under the Constitution, was given the power to write these enabling statutes that created the administrative agencies. So think about it like this. Congress realized that there are, as the country grew and grew in population and grew in wealth, that there are certain areas that are very, very specific, and you want experts working in those areas. And so they created these agencies to allow those experts to pass laws in those specific areas and allow Congress to do broader, more nationwide things and not industry specific. And then common law, which is the case law that's created when people sue the EPA or when the EPA sues people, and that creates a case, and the case is common law. So those are sources of administrative law. So what can administrative agencies do? They can make rules, they can enforce and license, issue permits, pay benefits, but they also can adjudicate. So we call dispute resolution or conflict resolution in administrative agencies adjudication before an administrative law judge. Okay, so let's get into, we've talked a lot about rulemaking. Let me skip quickly over this. There's formal rulemaking, informal rulemaking. The administrative agency needs to give the public notice that a rule change is coming out, and frequently industry is focused on this. So the comments are from business owners, trade groups, industry representatives saying that, this rule will be problematic, it's going to cost me a lot of money, please don't pass it, it's poorly written, it's poorly researched, or this is a great rule, we really need it now. Those comments are made. The rule is published in the Federal Register. You can look online. We did that in class, taking a look at the Federal Register. It's all electronic, and the public can make comments there electronically for a period of time. And then the comment period closes, and the administrative agency goes back and reads the comments and either decides to incorporate them and make changes or just go forward. So the American Medical Association, this particular case, the rule was issued, the proposed rule was issued, a comment period was declared, and then the final rule was made, but it was slightly different. And so the American, so the American Medical Association complained that after the comment period ended, the IRS went and replaced a test or a factors that they would consider in, it had to do with membership dues and how membership dues were paid to nonprofit organizations. So the American Medical Association is a nonprofit organization that represents doctors. People pay dues to be a member of it. And the non-due, there was a revenue change where certain previously not considered revenue monies were now considered revenue, and then they had to be taxed. So the AMA was complaining about that because after the comment period for the rule ended, the IRS made a change. So this flies in the face of why we were allowing a comment period, so that the administrative agency is accountable to the public for rules that they make. But in this case, the Seventh Circuit said that it was okay to make this change. It wasn't, the change that they made wasn't really binding on the agency, and it was largely part of the original proposal and really wasn't a brand new approach. So it didn't prejudice people who had commented on it. Take a look in the book. I think it's a good case. The final rule will only be invalidated when no notice was given if the final rule really changed fundamentally a pre-existing agency practice, and that wasn't the case here. So take a look at it, because if you haven't read the chapter and you're unfamiliar with the rule period and the comment period, it might seem more complex than it is. Okay, so moving on. So other powers of administrative agency, they get to enforce rules, they can issue licenses and do inspections. And then a big one we haven't really talked a lot about is adjudication, where a dispute's going to go before an administrative law judge, and that decision is for the most part final. You can appeal them. Right now what we're seeing in many administrative agencies is they feel that, so we call this adjudication in-house, right? So it's a administrative law judge appointed by the agency itself to resolve the agency dispute. So we're worried a little bit about conflict of interest. Is there pressure on that neutral to decide for the agency? Compare that to if I went to a state court, I could file there, someone who's not employed by the agency, paid by the agency, and maybe has a greater neutrality. There has been some evidence that some administrative agencies win when the dispute is in-house before an ALJ, and they lose when it's in a state court. Currently, right now, the Environmental Protection Agency and the Securities and Exchange Commission are under fire in the press for winning a lot before ALJs. And the SEC has now decided to revamp its administrative law judge procedures and the rules that say what cases have to go before that ALJ. Because they win 90% of the time when it's before an administrative law judge, and they lose 90% of the time, the SEC, when it's before a state court. Okay, so you do have a right of appeal, but it's to the head of the administrative agency, and that person then just makes a final determination. So the Trinity Marine Products case, when does an agency, so this gets more into detail with the power of the agency under the Fourth Amendment to conduct a inspection, the right of the business to assert a Fourth Amendment right for a warrant, the probable cause for that warrant. So a warrant is necessary for certain activities to be conducted under the Fourth Amendment for certain inspections. Sometimes administrative agencies don't need a warrant, but in this case they needed a warrant. Trinity originally turned the OSHA compliance officers away when they were asked to conduct an inspection, which is a Fourth Amendment right of the business. OSHA returned with an administrative warrant, was granted access, and Trinity later sued saying that the warrant, there was no probable cause, and so the warrant was invalid. So the question in this case is, so for probable cause, is there a lower standard for administrative agencies than for police officers or law enforcement? And the ruling, the Fifth Circuit, so let's take a look at the citation here on the slide. It's F3rd 198, Fifth Circuit, 2007. So F3rd, we're in federal court, Fifth Circuit. You know, I don't see a state name up there or an acronym that I can identify as a state. So I'm in federal court. And also, you're going to be in federal court for administrative agencies unless it specifically says it was a state administrative agency. So unless it was Cal OSHA or Cal EPA, we're in federal court. But I would like you to get comfortable with reading citations. That's really important. So this case held that the standards for probable cause are lower for an administrative warrant than for criminal warrant. And administrative warrants can be executed with less probable cause. And that's the holding, giving the administrative agency lots of power. But there are limits on administrative agencies. The executive, legislative, and judicial branches have various means of power that limit the authority of administrative agencies. The executive branch appoints the head of the administrative agencies, can encourage administrative agencies to directly work on public policy that are the particular president's objectives. Congress can use the power of the purse to limit funding for an administrative agency. If you recall, after Katrina, there was a lot of discussion about the funding for FEMA. A lot of mistakes that FEMA made and a lot of the problems that the people of New Orleans suffered, many felt were a result, or after testimony testified, how not just incompetence, but FEMA didn't have the funding that it needed to get done what it needed to get done. Also, Congress can restrict an agency's authority by passing a law that overrules an administrative reg. People can sue, so there's judicial review. You can sue, and that administrative agency will go to court and have to defend its actions. So just this slide. There's an arbitrary and capricious standard saying that if an administrative agency passes a rule that's arbitrary and capricious, Google those words, then people can sue and that rule can be overturned. So this is a Fox Television case. It's a federal case that eventually goes to the U.S. Supreme Court. And the issue was saying the F word on a live broadcast, and did it violate FCC policies? And FCC declared that it had a zero tolerance for the use of certain words that were inherently indecent, no matter what the context or brevity. So in the facts, you'll see that the F word, it was used once or twice, and it was very quick and really the true sense of an expletive. And it was in an acceptance speech. So was the FCC's action instituting a zero tolerance for the F word arbitrary and capricious? This citation is to the Federal Appeals Court, but the U.S. Supreme Court held that no. This is the appellate court decision in 2009. The U.S. Supreme Court held. Is there another slide? No. U.S. Supreme Court held that it wasn't arbitrary and capricious, that the agency's actions were rational and consistent with reasoned decision making. So just giving you an idea of review of an administrative agency's actions and how that works. So there's also another way that you can limit the power of administrative agencies, and that's to sue as a private citizen. So private citizen suits are suits that are brought against the administrative agency for failing to act in a way that's consistent with the enabling statutes requirement. So that's one limit on administrative agency power. Also, there's the Freedom of Information Act, where agencies are required to release documents. This works okay. There's lots of examples of where the administrative agency has avoided releasing documents, which is not cool. But sometimes FOIA requests or Freedom of Information Act requests really do give a lot of information to the public. And this is a legal way to do it, as opposed to WikiLeaks, which violates lots of rules and privacy rules, although has accomplished some things within that violation. So also, and this happens at all levels of government, the Sunshine Act, and this is a requirement that governments announce their meetings in advance, so that, and particularly meetings that are open to the public, so that people have an opportunity to come and attend and hear and speak. And most government meetings will have a public comment period. These meetings have minutes, so it gets in the minutes, and they're federally and state regulated. So states have all these same issues, powers, restrictions, abilities of private citizen suits, and everything that is at the federal government is at the state level as well. Do we want to talk about Consumer Federation of America and Department of Agriculture? Just quickly, we'll go back to FOIA. So this case, the U.S. Department of Agriculture had published a notice of a proposed rule that would regulate exposure to Listeria, which was a bacteria in meat and poultry. It issued a final rule, and which certain consumer agencies considered very weak in comparison to the originally more robust rule that was proposed. So the Consumer Federation of America sues the Department of Agriculture, or it issues a Freedom of Information Act request for access to certain calendars of USDA officials, and the USDA refused to release them. The Consumer Federation of America sues, and under FOIA, the agency is required to release agency documents. And the question was, were the public calendars of 5 senior USDA officials agency records? And this is a DC Circuit Court decision. The DC Court of Appeals held that, yeah, the 5 senior officials' calendars were agency records. The public had access to it. The calendars were always updated. They were distributed. And so a FOIA request the calendars would be encompassed in a FOIA request. And one small detail, the only calendar that did not need to be released was the administrative assistance calendar, because it was more personal time schedule as opposed to an agency. All right, so those are all the cases in Chapter 18. This was not brief. It's 28 minutes, but that's okay. I think we nailed it. And I'd like to move on in class now to contracts in Chapter 6. All right, I'll see you guys soon.